Chapter 11 is on state responsibility in international law. According to international law in general, responsibility is the necessary corollary of a right. So there is no right with absolutely zero responsibility. And every internationally wrongful act of a state bears its international responsibility. And it falls on the state who has committed the wrongful act to make the situation whole, so to speak. Please remember that there is a difference between state responsibility and international liability. So in general, the difference is that international responsibility is a broader term, and international liability denotes a state's civil responsibility in general. Civil responsibility means that the state has an obligation to make compensation or make reparations for injuries that non-nationals have suffered outside its national boundaries. But again, the main difference is that international responsibility is way broader term and just covers more territory and more areas. So according to the International Law Commission Draft Convention on the Responsibility of States for Internationally Wrongful Acts of 2001, again, Article 1 of that draft convention claims that every internationally wrongful act of a state entails the international responsibility of that state. Article 2 reads, elements of an internationally wrongful act of a state should be attributable to the state under international law and should constitute a breach of an international obligation of the state. So these are the conditions that need to be met in order to establish internationally wrongful act of a state. And Article 3 talks about the characterization of an act of a state as internationally wrongful, which is governed by international law. So what it means essentially is that the municipal law of a state cannot characterize an act as internationally wrongful or not wrongful, and it falls under the purview of international law to establish the wrongfulness of an act. Now, with those definitions and caveats in mind, there are a bunch of circumstances that preclude an act from being characterized as internationally wrongful. And these circumstances precluding wrongfulness include consent. In other words, if the state has already consented to the act, then obviously the issue of international responsibility will not apply. Number 2 is lawful acts of self-defense, which again fall outside the parameters of international responsibility. Number 3 is countermeasures in respect of an internationally wrongful act. In other words, in cases of retaliation or tit for tat circumstances. Number 4 is force majeure, which essentially denotes circumstances that fall beyond the control of the state. So if you did a wrongful act but it was completely out of your control, then the odds are it falls under the force majeure category. Number 5, you have distress, which is defined as an extremely perilous situation in international law. And finally, you have necessity, which means that the action in question was the only way of safeguarding a vital interest. So here on this slide, you have a bunch of notes on the so-called plea of necessity as a precluding ground. Necessity, for example, may not be invoked by a state as ground for precluding the wrongfulness of an act not in conformity with an international obligation of the state unless the act, A, is the only way for the state to safeguard an essential interest, and B, does not seriously impair an essential interest of the state or states towards which the obligation exists. And necessity, as you can see here, cannot be legitimately invoked if the international obligation in question excludes the possibility of invoking necessity, or the state has contributed to the situation of necessity. So necessity can't be a self-fulfilling prophecy type of situation. Now, one of the cases most often cited within the context of international responsibility is the so-called Rainbow Warrior case. This was a dispute between New Zealand and France that occurred in the aftermath of the sinking of the Rainbow Warrior. This was a vessel that was owned by the Greenpeace and was essentially sunk by the French military security service. So this is how the situation went. So the Greenpeace ship, the Rainbow Warrior, was planning to disrupt French nuclear tests on the islands of French Polynesia. And the French military security service set about sinking the Rainbow Warrior vessel. So in this case, New Zealand called out the French state under international law and tried the agents who had sunken the ship under its own municipal law, in other words, internal laws of New Zealand. French and New Zealand then agreed to arbitration. The arbitration was done by the UN Secretary General, and through the arbitration, France admitted responsibility, and in exchange for France admitting responsibility, New Zealand agreed to repatriate the French servicemen on the condition that they would serve out the remainder of their jail time on French territory at a French naval base in the Pacific. So this is a very interesting case because obviously the doctrine of non-intervention international law is pertinent to this case, and states according to this doctrine will be punished for contravening it. The case is a little bit of an anomaly, though, because it was settled through arbitration by one person, being the UN Secretary General. So it covers the issue of international responsibility, but in a very limited set of circumstances. Now, next slide is on the forms of redress for internationally wrongful acts. In other words, after an internationally wrongful act has occurred, what avenues for redress are available? Well, obviously the most evident avenue or outlet for settling issues of internationally wrongful acts is diplomatic means, which is government-to-government negotiations and so forth. And failing diplomatic means, you resort to adjudicative means, which include arbitral tribunals and claim commissions. And failing that, your last resort probably would be international adjudication through litigation and the court system, which could occur through, the International Court of Justice, International Criminal Court, and European Court of Human Rights, and so forth. Now, in order to establish international responsibility, there's a preliminary process, also sometimes called the validation process, that needs to be exhausted. And this validation process essentially establishes the preliminary conditions for international responsibility and for establishing that internationally wrongful act has been committed. So, in other words, this validation process is the procedure through which a claim should pass before it could be addressed on the merits. And these conditions are, number one, nationality. We talked about this before. It's also referred to as the active personality principle in international law. Number two is the exhaustion of local remedies. So, in other words, local remedies need to have been exhausted before you could take action for establishing international responsibility in an international arbitral or adjudicative or litigation process. Then you have the issue of non-waiver. In other words, states should not have waived either implicitly or explicitly the right to file a claim. Also, there needs to be a reasonable time frame between when the incident occurred and when you filed a claim. Well, obviously, in establishing that that time frame, the context of the claim needs to be taken into account. But the general rule of thumb is that the claim should be filed within a reasonable time frame. And then finally, you have the obvious stipulation of self-inflicted injury, which will not fall under international responsibility rules. Also, within the context of establishing this preliminary validation process, please remember the Calvo Doctrine, which covers international responsibility and jurisdiction in international investment disputes and contractual concession arrangements, which essentially claims that jurisdiction for these types of investment disputes lies with the country in which the investment is located. All right, so let's say that we have exhausted and we have established that validation process, and the next stage is to establish the fact that injury to an alien has occurred and the state has committed an internationally wrongful act by inflicting that injury. So how do we establish that? Well, number one, obviously, is the question of imputability. In other words, a state is only responsible for its own actions. It also includes acts of omission, so that's important. It could be an act of commission or omission to make a state responsible. Number two is the so-called denial of justice clause. In other words, it needs to be established that a failure by the authorities of the host state to provide adequate means of redress to the alien when his or her own substantive rights have suffered injury. So a blatant denial of justice needs to have occurred in order to establish international state responsibility. And finally, minimum international standards of justice benchmark needs to be met. In other words, the treatment of an alien in order to constitute an international delinquency should amount to an outrage, to bad faith, or to willful neglect of duty, or to an insufficiency of actions readily recognized or recognizable by an impartial observer. So this is a little bit of a subjective benchmark, but the general notion here is that an impartial observer should constitute an act lacking that international standard of justice benchmark in order to establish international delinquency. Now, these are a couple of examples of state responsibility within the context of the American-Mexican Claims Commission. So as you can see, some of these claims were in jibe with state responsibility stipulations and some were not. So for example, in Human's case, the Mexican government was found responsible. In Chatham claim, denial of procedural justice was established to be sufficiently grave to create state responsibility. But in Near claim, lack of diligence was deemed not serious enough to constitute international delinquency by the Mexican government. Now, next slide is on expropriation, and this covers issues like eminent domain, compulsory purchase, acquisition, and requisition. Now, this is an area of international law that is very controversial, actually. So the backdrop to this issue of expropriation, which occurs quite often in third world countries, is a December 1974 UN General Assembly resolution entitled Charter of Economic Rights and Duties of States. And this UN General Assembly resolution established the following: that developing countries must be entitled to regulate and control the activities of multinational corporations operating within their territory, that they must be free to nationalize or expropriate foreign property in conditions favorable to them, and in case of controversy over compensation, the domestic law of the nationalizing state should be supreme. This is a so-called act of state doctrine in international law. So when these issues of expropriation and nationalization and things of that nature occur in international relations, in cases of nationalization, the presumption is, like I said before, that it doesn't matter whether the nationalizing state is willing to compensate or not compensate for the expropriation or for nationalization. The act of state doctrine will ordinarily prevail, that the state is the master of its own house and it could nationalize foreign property. And the courts of another state cannot sit in judgment of the actions of this nationalizing state. So one mechanism to settle these nationalization claims is the so-called lump sum or global settlement mechanisms. And global settlement essentially means the settlement of the large majority of of cases involving expropriation that involve negotiations for lump sum settlement to avoid problems associated with sifting through individual claims. So in other words, as opposed to going through each single case or claim related to expropriation, the governments of two countries come together and come up with a lump sum solution in order to avoid those complexities involved with very time consuming individual settlement of these cases. And within the context of state responsibility, also remember this ex gratia payments, which means payments that are made because of a sense of moral obligation by the state rather than any legal requirement. Probably the most famous example of ex gratia payments was the USS Vincennes and Your Honor passenger flight 655. In which in this case, this United States vessel essentially brought down the passenger aircraft, and the United States did not assume legal responsibility for the act, but agreed to this ex gratia payment to the passengers, to the deceased passengers' families.